If what can I do? Because I overstayed here in America and I just gave birth last January, so my visa expired last year, December.
All right, so you're an overstay, and you're asking me to solve your entire life in a 30-second telephone call. It is absolutely impossible to do. The fact that you gave birth doesn't help you by overstaying 6 months. It doesn't make you any more legal. It doesn't give you any more justification to stay here. But in essence, you really need a consultation to figure out how you can get a green card. And that takes like 15, 20 minutes, because 30 minutes sometimes, because we got to figure out your entire life. So hold on one second, okay? The how do you get a green card questions, I can't answer as much as I want to. I can't.
It's not possible.
It's impossible.
It's not possible.
Not possible.
I have an approved VAWA since May 2016.
Right.
And I applied to adjust my status, but up to now I didn't get nothing.
What do you mean up to now you got nothing? You got the VAWA approved when?
May 2016.
And when did you file your adjustment?
2017 November.
Okay, so now you're waiting almost 2 years, right?
Yes.
Have you been watching my show at all, or are you kind of like a new viewer?
I think I'm a new viewer.
Okay, so about a week ago, we did every day a segment called Abadir Sues the Government. And what we were talking about is that in your case, and like many people's cases, when you file an adjustment application, what you're saying to the government is, I'm eligible for my green card immediately. Schedule me for a green card interview. And really, under the regulations and rules and under fairness and reasonableness, the government should schedule you for an adjustment interview and grant you a green card in less than a year. It really should be 6 months, but certainly should be less than a year. And what we were talking about in Abadir Sues the Government is that the government is violating everybody's rights by stretching out these cases 2 years, 2.5 years, or you go on an interview and they say, you'll hear from us, and then you wait another 6, 9, 12 months and you don't hear anything. In your case, you're almost 2 years into this already. So what we're saying is you have two choices, really. You can sit on your hands and do nothing and be frustrated. And there's really nothing. I mean, you can call the 1-800 number and say, hi, this is Tommy from Staten Island. Okay, right? They don't do anything for you. They'll say, okay, we'll pass your telephone call along, and you don't hear anything. You get a letter back saying, thanks for calling us. You can contact your congressman or senator, but they don't care about you, first of all, because you can't vote for them, and number two, they don't have any power with the Department of Homeland Security. So all they're going to do is write a letter, and Department of Homeland Security is going to write a letter back, and they're going to tell you in 3 months, you got to wait. Okay? So really, the only thing you can do is take matters into your own hands when they're delaying, a delayed visa is a visa denied. Okay? They have ruined at least 12 months of your life already because they haven't granted you a green card. You can't get that year back. You can't get that year back of your life, and you're entitled to your green card a year ago. So the only thing you can do is what we talk about in Abadir Sues the Government, and you can go back and watch our other shows, and maybe we'll run those segments again, is you file what's called a mandamus action against the government. Now, what a mandamus action is it's a lawsuit in federal court that you're asking a federal judge to force the government to make a decision on your immigration case. You do these mandamus cases on a pending adjustment that 100% you're going to get approved. There's no, you don't have any skeletons in your closet. And number two, on any case that's been pending for more than 12 months. We had a lady come in the end of February, heard us on my show, came in, hired us the end of February. I'm not sure the exact date in which Abadir, sometime in March, filed the mandamus, but it took like a week or two, I'm sure, to put the lawsuit together. By the first week of April, within 5.5 weeks from the time she hired us, she had a green card in her hand. And she had a pending her adjustment. She went on an interview. And didn't get a decision for 3 years. Now, your mandamus is to force them to get an interview, and then trust me, when a federal judge is overseeing this, they're going to grant you the green card right there on the spot. But really, the answer is you could sit on your hands or you could file a mandamus.
I'm tired of sitting. I really don't want to sit.
Then you're going to file a mandamus. Hold on one second, okay?
I can't even take my entrance exam.
I don't blame you. Hold on one second. You're going to file a mandamus. Let's go to Imad in Morristown, New Jersey. Imad.
Hey, how you doing, sir? How are you?
What's going on?
Good. I got two questions real quick.
Sure.
I married my wife last year, last year, 2018 in April, and I came as a tourist. She's a U.S. citizen. She has three kids.
Right.
I'm a work permit, and then in the middle of the case, middle of the year, she divorced me.
Okay.
So I had to withdraw my case before I got the entry.
Why did she divorce you?
Because we just didn't get along.
Just didn't get along. Work out. Okay, fine. All right, happens. Yeah. All right. So now the question is what?
Yes. And then I gotta withdraw. I withdraw my case. I got a confirmation from immigration that my case was withdrawn.
Mm-hmm.
Okay. And then I don't know. After a couple of months, I got the interview letter.
Okay.
I don't know why I got that, but I asked my lawyer. He said it's a system error. Will I be deported?
I hope not. There's no reason to go on the interview because nothing good's going to come from the interview.
I did not go to the interview. It did not come.
I wouldn't suggest going on the interview because if you go to the interview, it's not like you're going to get a green card or anything. You're already divorced, so there's no sense, no sense in going. Will you get deported? I don't know. You know, it's possible.
Was it a system error? Was it a system error?
It's just the process. I don't know about a system error. You know, you file to withdraw an application and they schedule you for an interview anyway. It's just, you know, nobody logged in that you withdrew the application. That's basically it. You know, whatever. It's not a system error and more. It's nobody looked at the letter that was ever written to withdraw the adjustment. Now, it would listen to me. It would not have mattered. It really would not have mattered whether the case was withdrawn or you got scheduled for an interview and you didn't show up. The fact is that you filed an adjustment. The government is aware of you now. Are you going to get deported? It's possible that the government can follow up with what's called notice to appear, which is a letter to go to see a judge to start the process of deportation. I can't promise you they won't. What I would suggest you do, instead of worrying about whether you will get deported or not, is maybe take things into your own hand. You live in New Jersey. I'm in Manhattan. I don't know if I have an answer for you, but it's worthwhile to have a consultation to see what options you have. So hold on one second. Oh, you have question number two. Sure.
Yes, question number two. I have my new girlfriend. I'm married to her for a couple of months now. Mm-hmm. She gets Section 8 and food stamps. Will that affect my case?
If you marry her, getting food stamps.
I married her already, but I didn't file yet.
Okay, so she's not your girlfriend. She's your wife.
She's my wife. That is correct. Yes,
all right. Sir. So yes, getting government assistance. She can't afford to support herself. Then she can't afford to support you. Your case would be denied. So she has to get off government. Certainly food stamps. We can talk about Section 8, but certainly food stamps. Yes.
But she gets a little bit of Section 8 and a little bit of food stamps.
A little bit of food stamps is a denial.
Okay.
All right, because she just for a little bit can't afford to support you. Just a little bit. That's all that matters. Hold on.
I have a heavy deal of support.
Imad, what words did you not understand that came out of my mouth? If your girlfriend gets government assistance, you're arguing with the wrong guy. I'm on your side. But if the government is giving your girlfriend government assistance because she can't afford her life, when you get food stamps, you are below the poverty level. You are below you are below the poverty level. You can't subside. You don't make enough money to feed yourself. How can she give you an affidavit of support when she doesn't make enough money to support herself or feed herself? It's impossible. You would be denied. So hold on 1 second. Right, Kim?
Right.
All right, let's go to Dorcas in Panama City, Florida. Dorcas.
Yes, good afternoon. I have a question. I'm doing okay. I have a question.
Go ahead.
I filed for my daughter 2016 November. She would be 21 December, and they receive it the November.
Are you a citizen or a resident?
I'm a resident.
Okay, so then she's going to end up in the F2B category, even though you filed before she's 21.
Right. But they have approved her 2018, and up till the time I have heard anything, when I called them, they said they don't have a visa for her.
Correct, because she's in the F2B category now. She doesn't get the benefits of the Child Status Protection Act because you filed for her 2 months before her 21st birthday. So they're right now up to February 1st, 2013. You filed for her what year?
2016.
Okay, so unfortunately, she has about 3 more years of waiting.
Wow.
Yeah. What country?
Jamaica.
Yeah, she has 3 more years of waiting.
I have one more question.
Sure.
My husband filed for my daughter and her baby from 2017. They asked for some paperwork concerning my husband's record court case. I did talk to you about this. From last year, September, they asked for some papers, and I sent it in, and they sent back to me that they receive it. And up till now, they haven't approved
Your husband is the citizen?
My husband is a citizen.
And they asked for his criminal records?
Yes, which he did have a domestic.
Let me ask you a question. Does he have some sort of sexual abuse of a minor?
No, sir. Just a domestic violence.
But there was no sexual abuse or anything?
No, sir.
Okay, and now this case has been pending since 2017?
From 2017 and
all right, first of all, they had no right to ask those records, because the only time they have a right to ask records is when there's a sex abuse allegation against the U.S. citizen. Okay, and then if there's no sex abuse allegation, there's no reason to ask for these records. Now, if this case has been pending since 2017, you already have your green card and your child's in another country, I'm going to refer you to Tommy's question, which I believe you were listening. Tommy called from Staten Island about her VAWA that was pending for 2 years. Your child's an immediate relative. That means that a green card should be made available to your child immediately. Now, it takes a few months to process I-130s and visa processing. It could take up to 12 months. But now it's almost 2 years or maybe even longer, and they're asking for criminal records for your husband that have nothing to do with the price of eggs in China.
That's right.
So you're in the same boat. You can call them and get frustrated. You can go to your congressman and get frustrated. You can file a mandamus and push this case along. Hold on one second. Hold on. That's what you need to do. Hold on, I'm telling you, a mandamus.
I've done an adjustment of status that was filed the end of February. I already did my fingerprints, and domestic violence occurred. And based on my research, it said that I should do a VAWA. So my question to you is, would I receive my work permit through this process, or would I have to wait until the VAWA starts in order to receive my work?
Was the domestic abuse by a U.S. citizen?
Yes.
Okay, if you file the I-360 and the I-485 simultaneously with the work permit application, and you check off C9 as the reason why you're entitled to a work permit, you don't check it off, you actually write it in the form, you would get a work permit.
Oh, okay. So it doesn't matter if the VAWA process starts or not?
No, the VAWA process has to start. You file the VAWA with the I-485. Okay, now, Sabrina, what I would suggest, because you're asking these questions, and these are your basic questions, and a VAWA case is a difficult case to prove because you have to prove bona fides of the marriage, good moral character, and that there was abuse, and then know how to properly file everything. I would suggest at a bare minimum, you hold on for a consultation, at a bare minimum. Okay? Hold on.
No problem.
I remember 2016, you helped me to remove my condition and get my...
Good job?
So, yes, very good. Thank you.
Good.
Quick question. I got my citizenship in 2019. My son was like 16, almost 17. He has his U.S. visa. Can I just apply for the N600 for him?
You didn't get... You said a U.S. visa or a green card?
No, he has he has his green card. Now he has the U.S. passport because through me he becomes a citizen.
So if he was... How old... When did you become a citizen?
In 2009.
Okay, so in 2009, your son was 16 years old and he had a green card and he was living with you?
Yes.
Yes, do the N600. He's a citizen.
So he have his U.S. passport because they tell me to apply for it. So I can just apply for the N600 now for him.
Yeah, do it anyway because he should always have two forms of ID throughout life that he's a citizen. So there's no question about it.
Okay, thank you so much.
Okay, you're very welcome.
I'd just like to find out. I have my dad who's been out of the country for a while, and he has one of those green cards that has no expiration date.
Right.
Now, he's about 70 years old, and I'd like to get him back in the country because I've been taking care of him, and he was there for some family matters, and he wasn't able to get back here.
When did he leave the country?
I'll think about almost 10 years now.
And you're a citizen?
Yeah.
Why did he leave the country?
he had to take care of his mother, and there was some family issue that he had to stay with her, and she passed away. So now he's there, and I'm taking care of him. So it's hard for me to go back and forth, and I would like him to be here.
He's not going to be able to come back on his green card because he's been out of the country for 10 years, and that's an abandoned green card. So if they know he's been out of the country for 10 years and he comes back, he's going to have a problem. He can do one of two things. He can go to the U.S. Embassy if you want to get him back here as quickly as possible. He can go to the U.S. Embassy, apply for a visitor's visa, and say, "Here's my green card. I lived in the United States 10 years ago. I could have lived here my entire life with a green card. I chose not to. What better way to prove that I don't want to live in the United States, because that's all you have to do to get a visitor's visa is prove I don't plan on living in the United States. Then I had the opportunity to live in the United States and I didn't." So almost every time you hand in an old green card, they'll give you a visitor's visa, and he can come up immediately. Okay, and then you can figure it out when he comes up here. Number two, you can do an SB1 visa. It's a little more difficult. I don't know if it would get approved because he's been out of the country for 10 years. What an
is that ST1V?
SB. It's a special. It's for a special benefit visa, but really think about it as SPA Bernstein visa, but it has nothing to do with SPA Bernstein. But it's the same thing, SB. Okay, and what you do is prove I really never intended to abandon my permanent residence. These are all the things that I had in the United States. These are all my ties to the United States, and these are the overwhelming reasons or superseding reasons why I couldn't come back for the last 10 years. The longer you're out, the harder it is to prove, and then they can give him back his green card or an SB1 visa to come back and live in the United States as a permanent resident. You can always refile for him again. You can do that from there. You can do that from here after 90 days if he enters on a visitor's visa. So, I mean, there's options. You can hold on and we can have a consultation about it. So hold on one second, okay?
Okay.
I came in a tourist visa on a B1, B2. Right. Then I overstayed.
Right.
But I got an employer who petitioned me. 765, the advance parole and the adjustment of status was filed.
But it was filed after you overstayed?
Yeah.
Right. And were you 245I? How long did you overstay? Let's start with that.
I guess that was around 6 months after that.
Okay, so because you can file under 245K, we never talk about it. You can file under 245K if the overstay was less than 180 days.
No, actually, I got my fingerprint last October, 2018. Then on February, I received a RFP telling that what's my status during the 485 was filed.
Okay, so all right, so that's all right. This is what the conversation I'm having with you. All right. So my question to you, okay, the general rule is if you overstay on your visitor's visa, you can't adjust your status on an employment sponsorship, but for two reasons. One is your 245I, which means that you qualified because you were the beneficiary, or your parents were the beneficiary of an approved petition prior to 1998 or 2001 if you were physically here in 2000. All right, so if you may be 245I. There's also something called 245K, which says that if your overstay is less than 180 days from the time that immigration receives your adjustment application, only on an employment case, and you can show you were not working illegally at all during this time period, you can still adjust your status. So I will say, hopefully, your overstay was less than 180 days when you filed the adjustment, and hopefully you didn't work illegally, and then you would still qualify for adjustment. Other than that, your adjustment's going to be denied.
But is there any relationship between the 485 and the 765? Because until now, I don't have that permit.
What words don't you understand? You don't get a work permit if your adjustment's going to be denied.
Oh, all right.
Okay. In order for you to get a work permit, and the relationship between the I-485, which is the adjustment, and the I-765, which is the employment authorization, the relationship is I filed a properly filed adjustment. This adjustment application is a legal application. So what I'm saying to you is for you to legally adjust your status, it had to have been filed within 180 days. Then you would get a work permit. Then you would get an interview for your green card. But if not, they're not going to give you a work permit just because you filed a form.
I understand.
All right, so you need a consultation because you're basically, what I'm hearing is you're doing everything wrong up to this point. Other than calling the show Calling the show is the first right thing you did. So hold on 1 second, okay?
I'm calling because I have two questions. The first one is my wife won a fight for me for the adjustment of status, and I have a question to ask about that because she'd been married 2 times before me, and back the day that was 2000. That was 2000. The first time she get married, and the second time she get married, I didn't work out. The second time she get married was 2004.
She married other people. And both cases, did any of these husbands get green cards?
Yeah, those 2 people have gotten the green card.
Okay,
yeah,
and she divorced each, and now she's married a 3rd time.
Yeah.
Okay, now when was the first green card? When was the first green card?
The first green card was 2000. She married in 2000. Okay. The first green card came out in 2001.
And when did she divorce that guy?
And, she divorced the guy 1 year after.
Okay, so she married in 2000. Guy gets green card 2001. She divorces him in 2002. When's the second marriage?
The second marriage happened in 2004.
And then that guy gets his green card. And when did she divorce him?
She divorced the guy in 2008.
Okay, and now she marries you when?
January 2019.
Okay, well, hopefully the 3rd time's the charm for her. Immigration, she could absolutely file for you. You're allowed to fall in love, fall out of love, fall in love, fall out of love. That's life. Happens to everybody, including myself. Okay? It happens to half of America gets divorced, falls out of love, falls back in love. What immigration is going to be concerned about, and you just have to have this in the back of your mind when you go for your interview, is they want to know that her prior 2 husbands, the prior 2 marriages, were legit marriages. That she's not in the business of just marrying people. That's her business, is not marrying people to give them green cards. So as long as she's prepared to answer questions and maybe has some documentation to show that the first 2 marriages were legit, it's not going to be a problem.
Oh, okay.
All right? And if you need help,
yeah.
Hold on 1 second, okay?
Yeah, that was the first question.
Oh, you have another one. Okay.
Yeah, the second one was because before that I have applied for asylum. I want to know if the asylum will be automatically canceled.
No, it's not it's not automatically canceled. What's happening with your asylum? What stage are you at right now?
I applied for asylum in 2016. That was around.
Have you been interviewed yet? I assume you have not been interviewed.
No.
Okay.
The only thing I got from them was.
So then you would have to withdraw the asylum case before you file the adjustment. You can't have both going. You would have to withdraw the asylum case first, then file the adjustment. You can't have both going at the same time.
Oh, I see. Okay.
All right.
Yeah, I think I'm gonna need your help for that.
I think so too.